Well, good afternoon, everyone. It's great to see so many clients join me each and every month for these lunch and learns. My name is Whitney O'Reilly. I run the estate department here at Cohen Seglias. We are a construction litigation firm and even more. So today, during this quick lunch and learn, we're going to talk about gifting. This is really important. At the end of each year, I get calls from many clients asking me what they should be doing before December 31st. So I thought this was pertinent a few weeks before the end of the year for us to spend a little time talking about gifting and how we can utilize that in our estate plan so that we can transfer as much wealth as humanly possible down to our beneficiaries. So a little bit of background about these webinars. A lot of you have been on my webinars before, but for anyone who hasn't, I have been practicing estate planning, estate administration, trust work for about a decade now. And each month I share a little bit of wisdom that I've learned over the years practicing so that my clients are better able to handle things that come up in the future, unforeseen things like finding ourselves in the middle of a pandemic, making sure we have updated power of attorney documents, making sure we have a will or trust in place, and making sure that our lifetime gifting matches with what we want to do at death. So for all of those of you who have been here before, you know that I like to do trivia questions and I like to give out prizes. Today we have a $100 gift card on the line. So pay attention. It's only going to be 30 minutes. I'll have a question at the end. The first to get it right will win the prize. Sometimes I've had people ask me, you know, if we're speaking with a crowd of adults, business entrepreneurs, you know, why do we have trivia? Why do we have games? This is only 30 minutes. Shouldn't we just get to the meat of it? And the answer is absolutely, we should get to the meat of it. This stuff is really important, but sometimes it's really important for us to be motivated to remember something. And webinars, it's hard to remember something. There's millions of slides, lots of code sections. So I just want to remind our brains that we should be remembering a little bit of this so that we can actually get a great takeaway from this. So let's get started. I was waiting till I got most of the people on the call. I see some people still coming in. Thanks again for joining. Again, my name's Whitney O'Reilly. We're going to be talking about to give or not to give. My information will be at the end of this slideshow. Certainly feel free to shoot me an email, give me a call, reach out anytime you have any questions. And again, I run the wealth preservation section of our firm. I've been doing this for more than a decade, so use me, get this knowledge, and make your plan a better plan in 2021. So first, we're going to talk about gifting, to give or not to give. So many people towards the end of the year want to give some money to their family members or friends. But what does that really mean? So it's important for us to understand under the Internal Revenue Code, giving someone a gift is a taxable event. Now you might say, oh my gosh, I gave my daughter $10,000 last year. I didn't think I had to do anything and I didn't file a tax return. Well, the answer is it is a taxable gift, but under the code, there's some exceptions. And so here's a little list of the following gifts that are not taxable. So we're going to talk about the annual exclusion in a few minutes, but that's a lot of times what people are trying to do by the end of the year is give that annual exclusion out to their family members. And so for 2020 and even moving into 2021, that exemption is $15,000. So you and I can give $15,000 to anyone we want in the entire world, and we don't have to file a gift tax return. There's a few other exceptions. Many of you know this, but it's always a good reminder. Tuition or medical expenses you pay for someone else. These are these exclusions, as in if you pay tuition for your grandchild, that doesn't count as a gift for gift tax purposes, and you don't have to pay tax on that gift, and it doesn't come off your lifetime exemption. Now, we're going to talk about these exemptions in a minute and why it's so important to understand how much we're giving and how we're giving. Of course, gifts between spouses are part of this exception, gifts to political organizations, and of course to qualifying charities are deductible from the value of the gift made. I didn't say earlier, most of you know now that we're in this virtual world, whether it's by webinar or Zoom, any questions that you have, stick in that question box. From time to time, I'll glance at it. If I see a question that I'm going to answer, I'll just make sure I answer it through this webinar. If it's something that I think is really pertinent, I might ask the question and tell you the answer. And if I think it is something very specific to the person who's asking it, I get a list of those questions and will certainly reach out to you afterwards, but again, reach out at any time. So again, if I'm telling you something or I'm talking to you about something, you have a question about it, certainly go over to the question box, type it in, and I'll give it a glance. So first, this is, if you only get to hear, you only listen to me for a few minutes and you take these gifting tips away, that would be great. I promise, listen to the end, you'll get some other good nuggets of gold. But here's just some basic gifting tips. One, this is really important. Make sure the checks are cashed before the end of the year so that the IRS can't argue that it wasn't a completed gift. Now, this might matter more for larger gifts, and we're going to talk about when we file gift tax returns, whether or not we're going to owe any tax on that transactions and the reason for doing it. Again, for the medical and the educational exception, make sure that you're paying directly to those institutions. So again, the IRS can't argue that it wasn't part of that exception. Another thing that's really important to understand, if we're gifting appreciated stock or other appreciated assets, make sure you talk to your tax team, your accountant, your attorney, because your children will get your basis in the property. And this is a great place to stop and talk about basis. This is important. This is always on the chopping block with the new administration coming into power. This is something that might go by the wayside. I know if anyone has listened to my previous webinars, we've talked about the Secure Act that was passed in 2019, eliminating the IRA stretch, which was an estate planning technique, just like this step up in basis technique. And that was eliminated for most people this last year. So every once in a while, it's good to re-listen to what's happening in the estate world so that my estate plan, my lifetime giving and my death giving match. And I'm able to give as much money as humanly possible to my beneficiaries, my family members, with incurring the least amount of tax possible. But right now, during your lifetime, you have something called basis. So this would be, I bought one Apple stock worth $1. So my basis in that stock is $1. And if, let's say, 5 years from now, I sell that Apple stock for $10, my basis is still 1. It was sold for 10, so I'll owe capital gains tax on the appreciation of that asset, so the $9 difference. And capital gains tax ranges from 15 to 20%. Again, this isn't like a complicated tax lesson. All this stuff is at the sort of most basic level. But it's important to know that during your lifetime, you've got this basis and you've got these capital tax ramifications to things that you do and don't do inside of your investments. When you pass away, you get a step up in basis on those assets. So that Apple stock that was worth $1, when I passed away, let's say it's worth $10, now I don't have to pay any capital gains tax on that appreciation. My new basis is $10. So part of the gifting plan affects death planning in that it's important to think about what assets we're gifting and what those ramifications are so that we can pay the least amount of tax possible. So again, we can get as much money as humanly possible out to our loved one, our spouse, our children. And for many of you on the call and many clients that I work with, like myself, I'm a business entrepreneur and own my own business. I want my business to succeed into multiple generations. So what's that lifetime gifting plan look like for me so that I can make sure that my company continues into the next generation and beyond? The next thing that's really important to understand about gift tax, I get calls about this all the time. My grandmother sent me a check for $15,000. Do I have to tell my accountant? Do I have to save some money for taxes for that asset? And generally the answer is no. The person giving the gift is responsible for paying the gift tax. So the example that we have right here is, I have a $100 gift card that I'm going to give to one of you today. So that actually is a taxable event. Do I have to file a gift tax return? No, I don't have to file a gift tax return because it's under that $15,000 exception. But it's important to understand that all of these things are still taxable events. And if I were to give you, let's say that $100, let's say instead of $100, it's $100,000. I think I'd have a lot more attendees if I was handing out a gift of $100,000, but we have a pretty good showing anyway today. But if I gave you $100,000, I would be responsible for that gift tax and filing a gift tax return. So the next thing that we're going to talk about is, let's stop for a second. There's a big warning here that says, you know, we're talking about the lifetime exemption, the estate tax exemption, gifting, and one of the things that I get calls on very frequently is my elderly mother or my elderly parents, you know, they're becoming not as able to take care of things. I think we're just going to gift the house to me. They're going to give me all their assets. Then we're going to get them qualified for Medicaid. And that way we can avoid taxes and we can avoid a spend down of their assets for Medicaid purposes. And the answer is stop. Warning, warning, warning. Don't do that. One, there's a 5-year look back for Medicaid purposes. So if, let's say, I find out that I am dying of cancer, I'm going to die within the next year. I think, well, instead of spending my money, if let's say I live longer and I need care from the government, I'm going to give it all to my son now. That way he'll have it, it won't get spent down, and if I live longer and I need Medicaid, I can get that Medicaid. And then even after I pass away, I don't have to worry about those assets being taxed. For at least in Pennsylvania and many other surrounding states that we represent, we have offices in Delaware, New Jersey, Maryland, New York, of course here in Philadelphia, Pennsylvania. There are state tax death ramifications. And if we're trying to avoid tax for federal purposes, state purposes, gifting purposes, that's not necessarily a good idea because we can actually trigger, by giving the asset away, a Medicaid ineligibility period of time where your parents don't have that money anymore, but they also can't qualify for government benefits. So we'll have another webinar in the future about Medicaid trust planning, but there's lots of other ways to accomplish that. It's also really important to understand, for death tax purposes, you can't just give all your assets on your deathbed. They used to call it deathbed giving. A long time ago you could, and you still can, but there's tax ramifications to that. So let's say I gave my son, all I had was $100,000. I gave it to my son, and within a year I passed away. That asset would actually come back into my estate for inheritance tax purposes, but stay out for step up in basis purposes. So it actually caused a worse tax ramification for me to give those assets before I passed away than to wait and give them at death. For Pennsylvania purposes, there's a 1-year look back period. So if you do it a number of years ago, it doesn't count, but if it's in that year period, it does. For federal purposes, for the federal estate tax, it's a 3-year look back period. One of the warnings I'd always say here, this is always something good to check in on. See if you have long-term care insurance. If you do, get it relooked at. Make sure you understand how it works. It's great to have it and can certainly come in handy if a loved one is not well and still has money. Maybe that long-term care insurance will kick in. And like I said, we'll have to do another webinar about Medicaid trust planning in the future. Many wealthy clients have parents who are aging and trying to figure out, what can I do with my parents? What can I do with their assets so that I can accomplish them having, a great retirement, a great end of their life, and at the same time getting as much money as possible for additional care for them or down to family members. So we've already talked about this annual exclusion. Just remember to check each year, the numbers change. For the last couple of years, it's been $15,000, but it was $14,000 for a couple years before that. And so now let's talk about the gift tax return. So you might say, okay, well, I can give everybody that I want to $15,000, but Whitney, I have many millions of dollars and I'd like to give them more. Or I'd like to slowly give stock in my business down to my children to start this succession plan. You're talking to me about a gift and that there's a gift tax. So what does that mean? So that's a Form 709, and a gift tax return must be filed if we're giving anyone or anything more than $15,000 in 1 year. We have to file a gift tax return. Now you might say, okay, well, I want to give $100,000 to my son. How much tax am I going to incur? And the answer is, well, one, I don't know that off first blush because I don't know what other lifetime gifts you gave. But let's just say you've never made any other gift. The answer is you don't owe any tax. It simply brings your lifetime exemption down. So let's talk about that for a minute, and I might move us to the next slide because I think I have some good dates on here. Yes, so this is your lifetime exemption and federal estate tax exemption. So they go together, but they didn't always go together. So right now you have a lifetime exemption of $11.58 million. So I can give my son $11 million and not pay any gift tax. I'm still required to file that tax return. And some people might say, why would I pay an accountant and an attorney a couple $100 more to file that gift tax return if I don't owe any tax? Well, there's lots of legal reasons we'd want to do that. One is we might want to start the statute of limitations. Two, we want to seal in the asset's worth. So sometimes if we're gifting something highly appreciating, like let's say Apple stock, we might want to seal the deal in that it's only worth $1 today. We only used up $1 of our lifetime exemption, versus having the IRS look back later and say, that wasn't worth $1, that was really worth $10. So you really used up $10 worth of your exemption. So it's really important to file those gift tax returns. But again, I've got under that $11.5 million. I don't have to worry about the gift tax ramifications. And the answer is that's not necessarily true. Right now in 2020, we have an $11.58 million exemption. When I pass away, that combines with the estate tax exemption, and whatever I didn't use during my lifetime, the remainder gets used at my death. So in total, during my lifetime and at death, I have a total exemption of $11.58 million. Again, that wasn't always the case. I certainly have trusts that were created before the 1970s when we didn't have a unified gift and estate tax. Now they work together. We're not going to talk today about the GST, the generation skipping transfer tax, but that's another tax that is unified in some respects, but has to be used in different ways. So that's important to understand if we're giving assets to future generations in trust that we might want to keep in perpetuity and keep away from taxes for even longer. So we'll do another webinar about that. 2021, we have an $11.7 million estate tax exemption. This all sounds great. We have a lot of exemption to give people a lot of gifts between now and when we pass away. The problem is laws are always changing. And in 2025, it's going to go back to, and this is through the Tax Cuts and Jobs Act, this high exemption that we're experiencing right now goes back down to $5 million adjusted for inflation in 2025. And I know a lot of you on this webinar, a lot of my clients certainly have above $5 million, whether in business assets, life insurance, totaled it all up. So it's something we need to be really aware of this year and moving into the next couple of years. How do I have a lifetime gift and estate tax exemption that passes as much money as humanly possible to my family members, and that we minimize as much tax as humanly possible? So here I just show you, in the 90s, the exemption was a little more than $500,000, but it was a 55% tax, to all the way up to today, where we have an $11.58 million exemption, but we have a 40% tax. So just remember, anything over that exemption during your lifetime or at death is going to incur a 40% tax. Now you might say, I'm saying that a little bit simplified. It is a little bit more complicated than just a 40% tax over the top, but for these purposes, good for us to know. So let's see what we've learned so far. So we've learned that giving anything to anyone as a gift is a taxable event, but there's an exception from that. So we've got the annual exclusion of $15,000, where you can give anyone you want in the entire world $15,000. It doesn't come off your lifetime exemption. You don't have to file a gift tax return. You can pay for people's medical expenses, tuition. Spouses can give each other gifts, and of course, charities are involved in that as well. Important takeaways: make sure you get that check cashed before the end of the year so the IRS doesn't dispute that it wasn't a completed transaction. If we have appreciated assets, let's think about what we're gifting before we gift, so that we can make sure that we're giving the right kind of assets when we're gifting. Remember, it's the person who's giving the gift that files and pays those gift taxes. Remember, we've got a lifetime exemption of $11.58 million for the rest of 2020, 2021, 11.7, but a big 2025, that's going to go back down to $5 million. So there might be some planning we want to utilize in the next couple of years, your lifetime gifting strategy. Again, big warning that if we're thinking that we want to move money around so that we can maybe qualify for government benefits, whether today or in the next couple of years for our aging family members, we've got to pause for a second and reach out to, let's say, our attorney, our tax team, and say, does this make sense, and is this causing a worse ramification than a better ramification? And then the most important, I think, takeaway from this, and of course I put it at the end, is how do we gift? Do I give $15,000 just outright? I just hand it to my son? Well, nobody's seen my son because he hasn't come out into this room. He's on a Zoom in school, but he's 8 years old. So I actually can't give it outright to him. I'd have to give it to a guardian for him, and it would have to go into a special account. So we could give it outright if he's old enough, or if he's younger, we might want to put it in something like a 529 account or a uniform transfers to minors account. That was also known as UGMA, Uniform Gifts to Minors Act. It's now the UTMA. That can be a great place to put gifts. One thing I'll say is I get calls at the end of every year regarding this, where we have grandparents who are wealthy and have been giving gifts to children from when, let's say, they were 8 years old up until 18, and now there's a couple $100,000 in this UTMA account, and they realize that it's going to end when they reach the age of majority, and they want to stop it because that child has a drug or alcohol problem, is immature, is not ready to handle that amount of money. And what my takeaway, I hope, for you guys today is, before you make a gift, whether it's small or large, sit down and let's think about your entire lifetime and death plan for what you want to do for your inheritors in the future, because it's hard to fix something that's already happened. It's easy to just do it right. And so the answer to that is, if we're over a period of time going to give more than a few $100,000, maybe we want to think about putting those assets inside an irrevocable trust. And of course, I'll have a webinar coming up in the future about different kinds of irrevocable trust and how they can protect assets from marital claims. They can protect assets from creditors. They can protect assets from their own minor beneficiaries. beneficiaries. You can have a little control over that gift, as in you can appoint a trustee to help give distributions to or for that beneficiary until they reach a certain age, or let's say for their whole lifetime. If we're transferring businesses, maybe we want to transfer the business stock inside of a trust so that we get an extra layer of protection during this business succession plan. So there's lots of valuable ways that we can gift to someone else other than just giving outright, whether it's through a minors account like a UTMA account, 529 account, or an irrevocable trust. So we're coming up to the end, and I can't believe how quick this happens. Maybe I'll start doing an hour webinar, but I know half of you are probably already asleep right now with me talking about gift tax ramifications. So I try to keep it as short as I can. But here's where we're coming to the trivia spot. So what I'm going to do is I'm going to turn the slide to the next slide. I think it's the next slide. I'm going to ask the question. The first person who puts it in that question box that's correct is going to win a $100 gift card, and we'll have your contact information. So here we go. Let's see if anybody learned anything from the last 30 minutes of me talking about gift taxes. So, and my screen, hold on. So if my husband and I each give my daughter Patience $15,000, and then separately I say, you know what, I want to give my close friend Heather $15,000 as well, do we have to file a gift tax return? And who pays that tax? So I'm going to wait a second, see if we get some questions. Normally you guys answer awfully quickly. Awesome, awesome. I already have a bunch of answers. And so the answer is, I'm going to wait one more second because it looks like a bunch of people are typing. It's always good to get your answer in before you find out if you were right or wrong. And the answer is, of course, we learned at the very beginning, we have this annual exclusion. You can give $15,000 to anyone you want in the entire world, each individual getting $15,000, and you do not have to file a gift tax return. And if for some reason we did have to file a gift tax return, I would have to pay for it. I would pay for the gift tax ramifications, not Heather or not Patience. So again, I can give anyone in the world $15,000. It's not limited to that number. It's limited to that number per individual. So if I wanted to give all 4 of my children $15,000, I still don't have to file that gift tax return. And of course, it's a wonderful thing that we're able to do, and it's a wonderful thing that it doesn't come off our lifetime exemption. So awesome. Thank you guys. There's at least somebody out there listening. A bunch of you answered. I appreciate it. Let me just get to my next slide. If anybody has any questions, obviously type them in. Whenever I see questions, like I said, I try to just incorporate them into what we're talking about. But if you have a question afterwards, certainly give me a call, shoot me an email. I'm an attorney. We could talk all day. I have multiple degrees in taxation and all the time in the world to talk to you. So certainly feel free to reach out. One of the things I thought about in doing this webinar is I try to figure out what are clients reaching out to me with, and what are problems that I see that maybe nobody told them about ahead of time. And this is one of those. What do we gift to people, and how do we do it? So I hope you got some takeaways on what to gift and how to gift, and then utilize your tax team to do it in the best possible way. And if you saw in the beginning, anybody who is a Shakespeare fan, to be or not to be came from Hamlet, and it's certainly a great play. Talks about death in many different ways. A king being murdered. Obviously, there's death ramifications. I don't know if there was a death tax at that time. I know at least here in the United States, it started, I think, in 1797. We used it to fund the Navy, and then it was abolished. And then it was brought back again in the 1800s. During the Civil War to help fund that Civil War. And then, like I said before, since 1916, we've had some form of death tax, whether just a federal tax or a state and federal tax. So it's always important, depending on what state you're in, to understand those ramifications, because lifetime gifting plays into what happens at death. So that's all I've got for you. I've got this great soliloquy, to be or not to be, that is the question. So I'll leave it up for a few minutes. You can certainly read it. I'll look to see if I have any questions for another minute or two. But again, I appreciate you all joining me. This is a lot of fun for me. I miss seeing a lot of you in person, although a lot of you know that we can do signing appointments, meetings by Zoom, so that we're at least able to see each other, even though we're not in person. I hope 2021 brings us maybe a pandemic-free, brings us a vaccine so we can have a pandemic-free end of the year. I hope you all have a happy holiday. And again, I appreciate you being my clients. If you're not my client, certainly reach out. I'm happy to help get an estate plan in place for you, help figure out that lifetime and death gifting. And again, look out for the next one. Even if you don't get anything from this, you could always win a prize. So come back again next month and join me for another Lunch and Learn. And like I said, have a great rest of your day. And to be or not to be, that is the question. Bye now, everybody.